A decision by bankruptcy judge Scott Dales of Grand Rapids, Michigan, shows just how much the Supreme Court's Taggart decision in early June has destroyed the value of the discharge injunction for people who have gone through bankruptcy. After all, the discharge is why you file bankruptcy, because the discharge is supposed to stop the harassing telephone calls and letters from creditors trying to collect debts. In Taggart, the Supreme Court said that if there is an objectively reasonable basis for arguing that whatever your collection activity is not in violation of the discharge injunction, then you cannot be held in contempt, even if it is in violation of the discharge injunction. And here's how that issue played out in the case before Judge Dales. The debtor had a car, but she surrendered the car to the lender immediately upon filing bankruptcy. After she got her discharge, the lender sent her a letter which, for all intents and purposes, was a demand in payment for approximately $9,000 deficiency that the lender incurred after selling the car at auction. Bankruptcy Judge Dales first analyzed whether or not that collection letter was in fact in contempt or in violation of the discharge injunction. The lender principally relied upon a bankruptcy disclaimer in this letter, which said rather ambiguously in bold letters, if you have filed bankruptcy, you may not be liable to pay us this deficiency. So, Judge Dales, after weighing all of the factors in this collection letter, decided that on balance, indeed, it was in violation of discharge because most consumers are going to view it as a demand for payment of a discharged debt. But that was not the end of the story. He went on to say, however, that there were some holdings, some cases previously in his district, which would have suggested that a disclaimer like that is enough to avoid having contempt charges laid on your head. And so he held that the lender, although having violated the discharge injunction, is not in contempt. Well, why does this really matter? Because at the end of the day, the debtor won. The reality of it is we're going to see many more cases just like this. But I fear we are also not going to see cases like this because let me give you an example. Let's say that the lender sends you an ambiguous collection letter trying to collect $350. Now you go to your lawyer who put you through bankruptcy and the lawyer says, well, listen, your retainer doesn't cover that, so I'm going to have to charge you $500 to try to hold these people in contempt and stop those letters from coming. And what's the debtor going to do? Well, I tell you what, it'll be cheaper to pay the debt or to compromise the debt than to assert your rights under the discharge. This, my friends, I think is something that Congress needs to deal with when and if the legislature in this country gets around to reviewing bankruptcy law again, because this loophole regarding enforcement of the discharge injunction is big enough to drive a truck through. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. I will be back same time next week with something else that's happened in bankruptcy, and if we're lucky, it will be interesting. Thank you, and good day.